The next case is Lori Silliman et al. Versus Jeremy Davis et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments. You may refer to children or victims by initials or like terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. I would like to reserve 4 minutes for rebuttal. Good morning, thank you. May it please the court. Good morning, Your Honors. My name is Diana Quesada, and I represent the appellants, plaintiffs, Mr. and Mrs. Silliman in this case. We are here today to ask the court to reverse the decision of the Summit County Court of Common Pleas, which improperly granted summary judgment in favor of the defendant's appellee, Dr. Davis, in his practice, on the grounds that the appellant's medical malpractice and derivative loss consortium claims were barred by the Ohio statute of repose. The central issue before this court is that whether the trial court erred in holding that the Ohio Savings Statute, which is RC 2305.19, does not extend to the filing period beyond the statute of repose. Appellants respectfully submit that the trial court's decision misapplies both statutory interpretation principles and the Ohio Supreme Court precedent. The Ohio Supreme Court has previously made a decision in Wilson versus Durrani in 2020. Well, we know this decision does exist, where the court has decided that the savings statute does not apply to the statute of repose when it comes to medical claims. We ask the court to not apply their ruling in that case in this case.
How do we do that, since it's a Supreme Court case that's right on point?
Yes, Your Honor. So this case was decided in 2020. The facts of this case precede this event. So the filing of the original complaint was filed in April of 2017. It was dismissed with a 41A without prejudice in May of 2018, and then refiled using the savings statute in April, end of April of 2019. Within that 1 year of refiling of the savings statute, well before this Wilson and Durrani was decided. I understand that there is also precedent that court's decisions are retroactively applied, not just prospectively, but we're asking that this court apply this prospectively. And the court decision in Peerless versus Electric Company versus Bauer, it states that there's one general exception to retroactivity, and is where vested rights have been acquired. I am arguing here that a vested right has been acquired when it comes to the savings statute.
And do you cite that case in your brief?
I do, Your Honor.
Okay, what was the name of it again?
It was Peerless Electric Company versus Bowers. And we asked that the court decide that this was a vested right. Counsel at the time that dismissed this case and refiled it did so under what they believed was a lawful ability that they were able to do. At no time had the court prior to Wilson versus Durrani applied that the savings statute did not apply to the statute of repose. And as well as DeCenso versus a Best Products Company, the court needs to consider 3 things, and they have the discretion of whether to apply a court's decision prospectively only and not retroactively. And those 3 things are: the decision establishes a new legal principle not foreshadowed in prior decisions, the retroactive application promotes or retards the rule's purpose, and 3, retroactive application causes inequitable results. This case, the ruling in Wilson was not foreshadowed. The Supreme Court has brought this issue beforehand in Antone versus Cleveland Clinic, and specifically declined to address this issue before Wilson in December of 2020. Additionally, in cases before, in a different 10th Appellate Court, this was not applied. Instead, they did say in Ways versus Reynolds, which again was in 10th District, did say the savings statute should apply to medical malpractice claims. And prior to Wilson versus Durrani, this legislator never went in to change either the savings statutes or the statute of repose when it comes to medical malpractice claims. We're not asking, if this was to happen after 2020. We understand there's a court precedent, a court ruling saying that the statute of the saving statute does not apply to statute of repose, but as I clearly stated beforehand, the issues that happened here happened way before this issue was ruled upon in Wilson. This was not something that could have been predicted by the plaintiffs in this case when they first dismissed their case. As well, it establishes a new legal principle. Again, this was not, prior to Wilson, there was no indication that the saving statute could not be applied to the statute of repose. Right? These two are two separate statutes that the legislator decided to impose and to have plaintiffs be able to file a medical malpractice claim as well as have a saving statute.
Counsel,
yes.
I understand what you're saying, but App.No was decided, and then the Supreme Court did accept Wilson, which they argued that App.No was incorrect. And so that didn't happen within a 2-week period. So there was a case pending in front of the Supreme Court where they were asked to look at the statute of repose and the saving statute again, correct?
That is correct. It was pending, Your Honor. But at the time, again, it was not decided, right? It was pending. Doesn't mean it could have been the other way around, because when we look at, there was another case as well that I was cited in my brief on page 4, Freisinger. That case specifically said that, it did not apply. The saving statute did not apply, did apply to the statute of repose. And it wasn't until Wilson that the Supreme Court decided to say, oh no, what we said in Freisinger was dicta. Okay, so how is an attorney supposed to know what they said in a decision that what came out before Wilson was just plain dicta? That was not something that could have been foreseen. It could not have been predicted by counsel that it was the court was going to overrule their own decision in Freisinger that the statute of the same statute did apply. Again, it was under the understanding that the same statute did apply. Again, I want to turn a little bit more into the legislative intent of these two statutes, right? The statute of repose is a 4-year limitation of when to bring medical malpractice. And it's with the understanding that it gives the defendants limited time of liability of when they can look forward to maybe getting sued, and it's 4 years. If the court decides to apply the saving statute, this does not leave an open-ended liability to defendants. That's not the case, right? We look at the plain language of the saving statute, and it says within 1 year of the commencement of the suit. That means the suit has to have already been properly commenced prior to invoking the rights that the saving statute has. If a case or complaint is not properly commenced, the saving statute is irrelevant at that point. So we're not asking the court to bring open liability to a defendant, not at all. We're just asking that if a case is properly commenced, that the saving statute apply to it, regardless of the statute of repose. And I know the appellees as well in the briefs that you guys have read that that the court in Wilson has said that this is a true statute of repose, right? 4 years past, you're done. You have no other liability. If you did not commence your suit, you're completely done, and that there's 2 exceptions into the statute of repose. Those 2 exceptions are written in there. That is correct. I'm not here to deny that. But what I will say is that statute was last amended in 2023. If the court wanted to say that the saving statute did not apply, they had time. The legislator could come in and change that in accordance with Wilson versus Germany. But there was no intent in that. Nothing changed said except the saving statute does not apply in this case. Right? That didn't happen. And if we are to follow what the court in Wilson versus Germany decided, we need to apply it to every statute does not explicitly accept the saving statute. I want to bring attention to a statute that not necessarily is involved with this, but kind of an example of the decisions in front of you today. RC 2305.06 is a contract in writing, and it limits that any action with a contract has to be brought within 6 years, so statute of limitation. This statute does not specifically state, except as provided in 2305.19, which is a saving statute. So are we going to read into this that because this statute doesn't specifically say that the saving statute applies or does not apply, that it shouldn't apply? That means every single statute of limitation, statute of repose that doesn't specifically mention the saving statute is going interpreted that it does not apply. These two were meant to work in conjunction with each other, not against each other, both the saving statute and the statute of repose. As well as 2305.113, the statute of repose, section A is the statute of limitations. There's two different limitations within that one statute. Does not accept the statute of the saving statute in that. So if we are to do what the court in Wilson is asking us to do, that means we need to read into every single statute of limitation that the saving statute doesn't apply. At that point, what's the point of the saving statute? If the legislator was supposed to go into every single statute of limitation, statute of repose, and doing an exception, or it does include it in there, then it's basically useless, in my opinion, at that point. But I think in this, it operates in equal footing in conjunction with the provisions of 2305.113. It's not stating that we're trying to leave an open-ended of liability to the defendant, not at all. We're just saying that if a case is timely commenced within the time limit of that statute of repose, and a plaintiff, for any reason, might have to dismiss it due to 41A, that saving statute should apply. I know it's a big feat that I'm asking this court today to not necessarily overrule the Supreme Court of Ohio, but to apply the ruling prospectively instead of retroactively. This case should be heard on its merit. It does not end a fair result. It's unjust. This case has been pending since 2017. Both counsels on both sides have been actively participating in the case, and all I'm asking is for this case to be heard on the merit and not to be dismissed on procedural error, if you might want to call that, or more of the ruling that the Supreme Court decided to do after the actions were taken in plaintiff in this case. Thank you, Your Honors. I will concede my rest of the time for rebuttal. Thank you.
Good morning, and may it please the court. My name is Brianna Perslipsky, and I'm here on behalf of the defendant appellees, Dr. Davis and his practice. Below, the trial court properly found that plaintiff's refiled complaint was not in compliance with the statute of repose and subsequently dismissed that claim on a motion for summary judgment. And where I'd like to start is exactly with this Wilson v. Durrani decision. As counsel noted, it is a proposition that when the Supreme Court issues a decision, it does not create law, but it defines the law as it has always been. The prior Antune case specifically flagged that, in the future the court may address whether or not the savings statute does apply to the statute of repose. This was certainly a decision that was forecasted in Antune, even though Antune declined to issue that ruling at the time. And what I would like to say about what Durrani did is it not only found that the savings statute could not apply to the medical claim statute of repose, but in subsequent proceedings, a motion for reconsideration was actually filed, which expressly asked the court to hold that the Durrani decision would be prospective only. The Supreme Court denied that decision. And I apologize, this wasn't cited in our brief, but I believe this court adopted that finding in Britton v. Seraldo, 2022 Ohio-600, that the statute of repose, the Wilson v. Durrani decision would be applied retroactively. So what counsel is asking today is not only that this court take a step in defiance of the Supreme Court's own precedent, but its own very recent precedent.
And counsel, you realize that you're supposed to supplement your briefs when you
I
cite.
do, and I apologize, I only found that case this morning as I was preparing, so what I would like to do is file a notice of supplemental authority so that this court does have that decision.
Well, we know our decisions, but I guess the whole point is so the other side has due process too, so that they can respond during oral argument. So it's not an ambush type thing. I'm not accusing you of that at all.
No, and I would note, the Wilson, I cited that case only noting that it, agreed with the Wilson v. Durrani decision, but we certainly did cite to Wilson v. Durrani, and it was in the subsequent proceedings in that case that the Supreme Court directly weighed upon the retroactive application of that statute. And this is in perfect conjunction with the purpose of the statute of repose, which is to provide a solid 4-year period in which a medical claim must be brought. It's different from a statute of limitations in the way that it runs from the date of the negligence to the date of filing, for 4 years. Whereas, as you know, with statute of limitations, it's triggered by the termination of the physician-patient relationship or the discovery of the injury. As the Supreme Court has said multiple times in Ruther v. Kaiser, in Antune, in Wilson, and subsequent decisions, most recently the Everhart decision, the statute of repose means what it says. 4 years is 4 years, and the court does not move outside of that 4-year period.
Counsel, this case is a little unique, isn't it, than some of the others that you have cited, or the other side has cited as well, in the respect that, this all was filed, and then, the refiling was within the savings statute before Wilson.
Correct, but again, it is when the Supreme Court issues a decision, it merely clarifies the law. Certainly, counsel would have been aware at the time of the Antune decision, which acknowledged that in the future the Supreme Court may revisit, visit in the first instance, whether or not the savings statute could apply to the statute of repose.
But their argument is there's a vested right in this particular case. Is there any way we can distinguish this case under Wilson?
Well, I would look back to Ruther v. Kaiser and Antune. Those decisions in conjunction held that the medical claims statute of repose applies to both vested and non-vested claims. So, if a claim has vested, let's say it's a delayed discovery claim, you had surgery years ago and it's only 6 years later that you discover it, the statute of repose.
Yeah, I was going to say unless there's an instrument or something left in here.
Right, there are, and I'm glad that you brought that up, there are express exceptions written into the statute, which the Supreme Court acknowledged in Wilson v. Durrani, and unless it is one of those express exceptions, there is simply no way to move outside of this 4-year statute of repose.
So it doesn't matter that it's inequitable or unfair or anything else?
No, it's not. That's a matter for the General Assembly. I'm aware of, I don't recall if we had referenced this case in our brief, so my apologies, but there's a case out of the 5th District Court of Appeals, Mercer v. Keene, somewhat of a different issue where the plaintiff actually died during the course of the proceedings, and the complaint was amended to add a wrongful death claim, and the Court of Appeals found that the statute of repose actually barred that complaint, even though barred the wrongful death claim, even though it was initiated in the course of active litigation. And the reason I draw the court to that opinion specifically is there's language in that opinion to the effect of, we recognize that this decision is a harsh one, but to the extent that to the extent that it is a harsh one, that is a matter for the General Assembly to address with the courts.
And of course, the Supreme Court has interpreted the General Assembly.
Of course, and in this case, it found that the statute of repose applies regardless of, whatever language there is in the savings statute. It, because the savings statute is not one of the express exceptions within the statute of repose, it doesn't apply if a claim is filed outside of that 4-year period. It is time barred. And I believe that's the majority of what I would like to address. Only I would like to, emphasize that the holding in Wilson v. Durrani is very limited. I hear counsel's concerns that the analysis used in the Wilson decision could potentially limit the application of the savings statute beyond the statute of repose, but the analysis there was very specific, and a lot of it relied upon the particular nature of a statute of repose, which is meant to bring finality to claims. It's not, as I read the decision, going to have any impact on statutes of limitations for other claims. It is very narrowly tailored to the language of the statute of repose, which only involves very limited express exceptions, and the savings statute is not one of them. And so unless this court has any further questions, I would respectfully ask that it affirm the decision of the trial court below granting judgment in the defendant's favor. Thank you.
You have about 4 minutes.
Thank you, Your Honor. As the opposing counsel says, she does not believe this creates new law that clarifies the law. I would argue that the ruling in Wilson did create new law that did not exist prior to their decision being published. I would like to bring your attention to the appellant's brief at page 6. In that, I quote the dissent of Justice Stewart, in where she reads, "I agree with the majority opinion. It is not our job to establish legislative policies or to second-guess the General Assembly's policy choices." Majority opinion at paragraph 37. But that is exactly what the majority is doing here when it goes out of its way to manufacture reasons to find that two otherwise perfectly compatible statutes are operating at odds with each other. I would ask that this court read the dissenting opinion in Wilson. I think that brings very much clarification at that the court wasn't looking to clarify existing law, but to create new law, as I said, because prior to the decision in Wilson, the courts were operating as though the same statute and the statute of repose were together and not against each other. Again, in the case of Wade versus Reynolds in the 10th District, the court allowed the same statutes to be applied in with the statute of repose. Even prior to Wilson, the appellate court allowed the same statute to be applied to the statute of repose. And again, it wasn't until that case which the Supreme Court decided to make its own law saying that the two didn't work together. There is, in opposing counsel did bring up Britain versus Serrano, which I did actually find, so it was not a big surprise, but I will argue that the case here differs in that case, although mentioned vested rights, didn't truly argue vested rights or argue legislative intent when presenting the argument in front of the 9th District. It went in a way that, okay, maybe a little bit of vested rights, but it go into it create a new law that it will bring an unjust result. In addition to establish a new legal principle that was not foreshadowed in prior decisions. We're not here to, again, extend the liability of any defendants. We're here to ask the court that if a medical malpractice case is timely commenced, that a statute that is in existence at the time, as when the same statute applies, there is nothing in the statute of repose that says the same statute does not apply. Again, I want to bring in the language of the saving statute. The saving statute itself provides for explicit exceptions to the rule in that it does not apply to certain sections of the revised code. Nowhere in there does it say that medical malpractice actions cannot be, that the same statute cannot be applied to medical malpractice. And then we turn into the statute of repose. Nowhere in there does it say that the same statute does not apply. What I don't understand is, are we to just assume that the two statutes that are supposed to work together are actually in conflict with each other moving forward? I'm just asking the court to interpret these statutes as they're written, not as how the court wants them to be written. Again, that is the legislator's job. Again, I'm just asking the court that Wilson should not be applied retroactively, that the legislator never intended to exclude medical malpractice from the operation of the same statute, and that the trial court's ruling leads to an inequitable result. And I ask this court to reverse the trial court decision and allow the appellant's claims to be heard on its merits. Thank you.
The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision as soon as it's released. And the opinions are also posted on the Ohio Supreme Court website. Thank you both for your presentations.
Thank you.